This is how many courtroom stories begin. Quiet, procedural, almost forgettable. A minor traffic admission, a fine, a quick resolution. But pay attention to how Judge Simpson handles this opening. He moves fast, clears the first issue cleanly, and doesn't waste time. That tells you something immediately. This judge is focused, efficient, and not here for drawn-out theatrics. Now look at the defendant's tone. Respectful, cooperative, promising to pay within 2 weeks. On paper, everything looks stable. But courtroom veterans know this pattern well. The calm at the beginning often hides the real issue waiting underneath. And then comes the pivot. Then on his other case, what are we doing? That single line signals a transition. We're no longer in routine territory. Something else is coming, and it's going to shift the tone completely. The key thing to watch now is consistency. Will the defendant maintain this composed, cooperative behavior when pressure increases? Or will cracks start to show? Because in court, your first impression sets the baseline, but it's your reactions under pressure that define the outcome.
Packard Road near Gulfside Road, Pittsfield Township, Washington County, State of Michigan, that you double parked the motor vehicle?
Yes.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When do you think you can get that paid, sir?
I can have that paid within the next 2 weeks.
All right, get it paid before the end of the year. Can you get it paid before the end of the year?
Yes, sir. Yes, Your Honor.
So just pay it by December 30th, 2025. All right. Then on this other case, what are we doing?
Sure, on that one, we're just going to request an adjournment for discovery.
And if I may, Your Honor.
Yes.
Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Mr. Stewart.
That I signed actually back in November.
JIS just is not updated appropriately. Oh.
It's just JIS is not updated. All right. So no reason to yell at the attorney, Perry. She did everything she was supposed to do. I knew that. I was going to defend her to January 21st, 2026. That's a bit of time out there. All right. And because we can't.
Yeah.
Okay. And then, all right. In this case, this bond will continue. Counsel approach on a separate matter. Ms. Fleming?
Yes.
Were you huffing on Zoom?
Just like that, the entire hearing flips. One direct question, and the atmosphere changes from routine to intense. This isn't a vague accusation. It's specific, pointed, and repeated. The judge isn't fishing. He's verifying something he's already been told. And that's important. When a judge asks a question like this, it usually means there's already some level of confirmation behind it. Now focus on the defendant's response pattern. Confusion, hesitation, denial. That's a classic stress reaction. But in a courtroom, hesitation can be as damaging as admission. Judges are trained to read behavior, not just words. And here's the deeper issue. This isn't just about inappropriate behavior on Zoom. Huffing substances like compressed air is extremely dangerous. We're talking about something that can cause instant death. So now the judge isn't just evaluating honesty, he's evaluating risk. At this point, the case shifts from legal procedure to personal safety. And once that happens, the judge's priorities change completely.
I'm sorry?
Were you huffing?
No, I was not.
Are you sure?
Yes.
So if it was reported to me by 2 people that you were, they wouldn't be telling the truth?
I don't understand what you mean. Was I huffing when?
Today.
Today? No.
Where do you live?
I live at Chittister Place Apartments.
How long will it take you to get here?
I don't have a ride or anything. I don't know. To get there today?
Yeah, today. We saw you doing something you probably shouldn't have been doing.
What do you mean, sir?
Were you huffing?
Was I huffing just now? Like on camera? No.
Okay, today off camera, on camera, you've been huffing?
No. No.
Not at all?
No.
So if you came down here and I sent you over for a test, everything's going to come back negative?
Now the judge applies pressure in a controlled, strategic way. He introduces the idea of testing, not arguing, not accusing, just verifying. This is a classic courtroom move. If someone is telling the truth, they should have no problem proving it. But if they're not, this is where the story starts to collapse. Notice how the defendant begins to struggle, not just with the question, but with logistics. She doesn't have a ride. She's unsure how to get there. These details matter, because when someone is under pressure, small inconsistencies start to appear, and the judge is watching all of it. Every hesitation, every excuse, every shift in tone. This moment is critical because it's no longer about what she says. It's about whether her actions align with her claims. And right now, that alignment is starting to break.
Yes.
It will?
Yeah.
Okay, you're going to need to find a ride. I'm going to need you down here.
Okay, sir. I don't know how I could get there.
Ms. Fleming, I'm gonna give you a call, okay?
Okay.
Thank you.
Thank you.
And counsel approach first.
Good. Public Defendant Lauren Perry on behalf of Ms. Fleming. Say your name for the record, please.
April Flynn.
All right. Well, thank you for coming down. Miss Fleming, I'm going to ask you again.
I did. I was.
You did what?
I huffed.
You were huffing.
There it is, the turning point. The denial collapses into admission, and in court, this kind of reversal carries serious weight. It's not just about what she did, it's about how she handled it. First denying, then admitting under pressure damages credibility immediately. But look at the judge's response. He doesn't react with anger. He shifts into concern. He asks about frequency, duration, intent. That tells you something important. This is no longer just about enforcing rules. It's about assessing danger. When he says, "You're going to end up dying," that's not exaggeration. Huffing is one of the most unpredictable and lethal forms of substance use. So now the courtroom dynamic changes again. It's no longer prosecution versus defense. It's the court versus the risk of losing this defendant entirely.
Yeah.
I'm sorry. I made a mistake.
Why weren't you? Why were you lying to me when?
I panicked. I just panicked. And I'm so sorry. I'm really, really sorry.
Ma'am, how frequently are you doing this?
I
mean, are you doing that every day?
Sometimes.
I mean, you're going to end up dying.
Can you give me
I
another
mean,
chance today, please?
Is that what you're trying to do? Are
No,
you trying to kill yourself?
no, I'm sorry. I just,
Okay, but how long have you been doing this?
I don't know. I've tried it off and on for a year or so.
Have you thought that you might need to get into some type of treatment or something? Have you?
I need to.
But you haven't done that.
I guess I haven't had anything like this happen. I plan on getting in touch with.
Who are you going to get into? You don't even know.
Huh?
You don't even know who you're gonna get in touch with.
Well, I know I have to speak to,
Well, I will say Miss Fleming does go to therapy at Huron Valley Consultants.
yeah,
As I've stated, we've been working on getting those medical records. I have reviewed some of those medical records. It indicates they do talk, and Miss Fleming's on methadone. We're still in the methadone program. So I do know, I will say that there are entries that they've had these types of conversations about her past use. So I think it's something that Miss Fleming knows that she deals with.
Yeah.
Have you told them that you're huffing?
This exchange reveals a deeper problem: lack of honesty in treatment. The defendant is in therapy on methadone, has medical support, but hasn't disclosed this behavior. That's a major issue, because treatment only works when it's transparent. If the professionals helping her don't know what's happening, they can't intervene effectively, and the judge picks up on this immediately. It reinforces a pattern: withholding truth until confronted. From a legal perspective, this matters a lot. When deciding whether someone can remain out of custody, the court looks at their support system. Is it real? Is it working? Is it informed? Right now, that system looks incomplete, and that makes the judge's decision much harder and much more serious.
No,
You
I know I have to. I
Sure.
plan on speaking to my counselor today.
When's the next time you see your therapist?
I can see him tomorrow morning.
Okay, so Miss Fleming, here's what you gotta understand. For me, when you tell me that you have an appointment, when you tell me all these things, it becomes hard for me to believe whether or not you're telling me the truth.
I understand that.
And that's because I asked you a series of times when you were on Zoom.
I freaked out. I should have said the exact truth, and I'm so sorry, Judge Simpson. Please give me a chance today, please.
Well, Miss Feltus, you want to say something?
I do, Your Honor. Miss APA Cook was able to review the YouTube footage, and we shared with Miss Kearney a screenshot that did show the defendant with the canister in her hand. I recognize that canister to be what I commonly refer to as dust off or computer cleaner, a type of compressed air.
This is the moment where doubt is replaced with evidence. A screenshot showing the canister, identification of the substance, explanation of its effects. This isn't speculation anymore, it's confirmation. And notice the prosecutor's approach. She's not aggressive, she's concerned. She emphasizes the danger, the possibility of immediate death, and the need for intervention. This is a powerful shift in courtroom dynamics. When both sides acknowledge risk, the judge's role becomes clearer. It's no longer about deciding guilt, it's about deciding protection. And the request for bond modification to treatment shows that even the prosecution sees this as a situation requiring help, not just punishment.
I'm very familiar with this drug, and I know that any time that you use it, it can cause instant death.
Yep.
This is a drug that is extremely dangerous, and the way that this is being ingested can lead to long-term issues as well as immediate death. The brain can die every time you do this. I think it's clear the defendant's very scared. I think it's clear that she wants to change. She wants to stop using. I really want to see her again, Your Honor. I'm very worried that we're not going to see her again. I truly, truly want the court to hear that this coming in from a place of compassion and concern, not a place of bond violation. This coming from a place for the people of actual concern. We will not see her. I am requesting that the court consider bond change with a release to treatment for her to get some help. But I do know that my experience with this drug and all the education I have surrounding drugs in general leads me to believe this is an extremely risky behavior. I ask the court to consider a bond change.
Please, Your Honor, please.
Sure.
I do know Miss Fleming does have a medical team around her. She sees her primary care doctor consistently. As I stated, she is in therapy. I think everyone's concern for Miss Fleming is warranted, especially the circumstances that this arose out of. I'm happy to work with her and get information to the people in the court if the court allows her to stay out of custody. Obviously, if she's in custody, that will take place too. I'm just asking that the court consider letting us work on that while she's out of
Please,
custody.
please.
She does have some medical issues that, and that's partially why she sees her doctor so consistently. This is an old retail fraud. I do, this case, I don't believe has anything to do with her use or anything like that. I just asked for
Well,
a chance.
might though, because if she's been using for off and on, as she's indicated, a year, this offense is in June of this year.
Well, I mean, I don't know exactly how long I've been using it. It's been for some months now. I don't know if it's been a year exactly.
Okay, Ms. Fleming, here's how I know you're an addict. You tell me one thing, and then when all of a sudden that doesn't seem like that goes your way, you change your story. You did that in rather rapid shot fashion when you were on Zoom.
I'm so sorry.
No, Miss Fleming, sometimes things happen for a reason, and not all of them we like what happens, but they happen for a reason. And maybe it also goes to what Ms. Feltes said.
Please keep me out of custody today. Please, Judge Simpson, please. I'm begging you.
You can't stop.
I am stopping. I'm done. I promise. I
And
promise
here's
with
my
everything
problem,
in
Ms.
me.
Fleming. Ms. Fleming, here's my problem. You've already lied to me today, repeatedly.
This is where the judge draws the line. He directly addresses the core issue, trust. And once a judge says, "I can't trust you," the entire case shifts, because trust is the foundation of bond decisions. Without it, release becomes a risk the court cannot justify. The defendant is pleading, apologizing, promising change. But from the judge's perspective, he's already seen a pattern: denial, reversal, inconsistency. And then comes the most important statement: "You're not dying on my watch." That defines everything. This is no longer about punishment. It's about responsibility. The judge is making it clear he would rather restrict her freedom than risk her life.
Repeatedly.
I am so sorry. I am so sorry. I got here as soon as you said, please to come down. I got right on the bus and I came
It
here.
was either going to be, and I think you understood, if you didn't come down, we were going to come and get you because there was going to be a bench warrant.
Okay. I think you're scaring me straight.
No, I don't think I have. Certainly not yet. But I'm going to let you know, if you think for 1 minute that I'm going to sit here when I know what I know at this point and have you die on my watch, and I haven't used what tools I have to try to make sure that you stay alive, you're sadly mistaken.
Please don't take me in today, Judge Simpson. Please, I'm begging you. Please, please, everything in me, please. Please give me one more chance, please. Please, Judge Simpson.
And I will add, Your Honor, Ms. Fleming was honest with me when I spoke with her. I think she understands the reality of the situation.
Anything else you want to tell me?
Just that I'm going to tell you the truth from here on out. I swear on everything in me. I swear on everything in me, Judge Simpson. I swear on everything in me. And I voted for you.
Doing about the 65 other thousand, but thank you, I guess. You're not dying on my watch, not tonight.
I'm not going to die tonight.
Done.
Please.
I'm done listening. Listen to me now.
Okay.
You're not going to die on my watch. I can't trust you I don't know what therapeutic routine you have, what you have surrounding you that I can safely let you out. Because whatever you're doing at this point, you do it, you go home and you're huffing.
I won't,
But yeah, I know you're gonna tell me I won't do it. You're gonna tell me that all that
please, Judge
stuff.
Simpson, please.
Miss Fleming, I've heard it all before. And then the next thing I know, before we even get to your case again, guess what? I'm online reading about your obituary and I'm not doing it. I'm just not doing it. If they can get the information, I'll take a look at it and I'll potentially reconsider. I'll set a review of her bond on December 22nd, 2005 at 9 o'clock. But at this time, her bond is revoked, defendant's remanded.
I'm arrested? Oh my God.
Get somebody down.
May I appear for Zoom? Vice for that.
Pardon? Yes.
Thank you.
Yeah, I was gonna say that.
Thank you.
Yes. That's not a normal.
This is the final outcome, and it reflects everything that built up throughout the hearing. Bond revocation means the court has determined that the defendant cannot be safely trusted outside custody, not because of the original charge, but because of the risk demonstrated during this hearing. The judge's reasoning is clear: repeated dishonesty, confirmed substance abuse, and a lack of reliable support systems. Combined, these factors create a situation where release could lead to serious harm, or worse. It's a difficult decision, but one grounded in prevention. Sometimes the justice system isn't just about accountability, it's about intervention. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.